1. I'd like to start with I will call this meeting to order, and I will dispense with the Pledge of Allegiance, given that we are operating through video conferencing. Let's start with a roll call of the members that are, or the commissioners that are present today. I'm Patrick McNally, and temporarily serving as your chairperson. Ms. Westlake, are you present?
I am present.
Mr. Carr, are you present?
I am present.
Ms. Powell?
Present.
Ms. Warren?
Present.
Okay, and I understand that Commissioner Kerry Rogers is logging in with us and should join us shortly. All right. Now, I want to advise anyone that is appearing before the commission that you have a right to appeal any adverse decision of this commission. If you're dissatisfied with the results of a hearing by the commission, you have a right to appeal. Your appeal must be timely filed with the Chancery Court of Davidson County, Tennessee. And I would advise you to seek legal representation to perfect your appeal. Now, we are conducting this meeting, I hope, by telephonic and video conferencing. We will need on the record a motion that passes explaining that because of the COVID-19 pandemic and the governor's executive order number, Costonas, are we at number 64 or 65?
We're actually at 78.
Oh my goodness. All right, because of the governor's executive order number 78 that's extending the use of telephonic and video conferencing for meetings, we will need a motion on the record, and also the motion will need to explain that this hearing is necessary for the public necessity. Have I covered that correctly, Mr. Costonas?
That the hearing is necessary. The business of this essential business of the Metropolitan government, and that meeting electronically is necessary to protect the public health and safety in light of the COVID-19 pandemic.
And if anybody needs a little help with making that motion, it is about a third of the way down in our February 25th minutes. Is there a motion on the floor?
I make a motion due to the executive order 78 given by the governor that this meeting be conducted electronically due to reasons for COVID.
I'll second that motion.
All right, I'm going to call off the names here. Mr. Rogers, I see that you have joined us.
He's talking to you right now, but I don't think we can hear him. So what I'll do is I'll give you a copy.
All right, Ms. Westlake, how do you vote on the motion?
Aye.
Ms.
I
Powell?
vote yes.
Thank you. Ms. Powell?
Aye.
Ms. Warren?
Aye.
Mr. Carr?
Aye.
And Mr. Rogers, can you hear me now?
He's not able to hear.
Okay.
Mr. Rogers is online, but he can hear you, but he cannot comment back.
Okay.
I think he can hear me, so he's indicating he's voting yes on the motion.
All right, so the motion passes. Now, have we had an opportunity to review the minutes from the February 25th, 2021 meeting?
Yes, I have.
Okay. Is there a motion to approve the minutes?
I will make a motion to approve the minutes from February, what was it again?
February 25th, 2021.
I would like to make a motion to approve the minutes from the February 25th meeting, the February 25th, 2021 meeting.
All right, is there a second?
I second that motion.
All right, I'll do a roll call. Ms. Westlake, how do you vote on the motion to approve the minutes?
Aye.
Mr. Carr?
Aye.
I vote aye.
Mr. Warren or Miss Warren,
Aye.
and Miss Powell.
Aye.
All right, and Mr. Fields, can you get Mr. Rogers' vote?
He is actually calling back in right now. He went back out and is
All right.
coming back in, so I cannot at the moment.
All right, well, the motion passes. Now, we've done the roll call, done the minutes. Let's see. Mr. Fields, it looks like we're ready to go on the agenda now.
Yes, sir. Okay.
Thing up here is a wrecker and towing services review of driver application of Jason Chad Owens.
I'll speak with you just as well. Let me go ahead and bring Mr. Owens into the meeting.
Okay.
I'm gonna press. Hello, Mr. Owens? Hello, Mr. Owens, Mr. Mitchell? Okay, I'm gonna bring you in the meeting. Okay. Mr. Chad Owens, who is the applicant, Mr. Jim Mitchell, who is the operator of the wrecker company, Dad's at West Nashville, is on the line with us. In making his application, Mr. Owens, he was fully revealed everything he needed to reveal. However, there were a couple of things I figured you probably should look at. None of them preclude him from being a wrecker company, a wrecker driver. In fact, I would, under normal circumstances, I would have approved him myself, but I felt like I should go ahead and bring him in front of the commission, but he is qualified. Mr. Mitchell's here to speak on his behalf. He's been an employee of the company for the last 2 or 3 years as a worker in the yard and so forth. He's not been driving, of course, but he's qualified and and as far as I can tell, his application is compliant and ready for you to review.
Mr. Owens, do you have a statement, explanation as to your application and the criminal offense?
Well, I was found guilty on the charges. Had Iraqi past, and Jim Mitchell here, he gave me a chance, and that really changed my life. Was had a little baby, and was just trying to build a new life for myself and live in better ways. And doing everything I can to make that happen. Mr. Jim here, he's really stood behind me and, pushed me forward. And like I said, give me a chance. I'm just trying to make the best of it.
And you've been working at Dad's for a number of years now?
Actually, he's been working at West Nashville as the lot man, and what the lot man's jobs are is getting the cars aligned and in order, inventory in the cars, operating the forklift, but not operating the wreckers. He's not driven any wreckers. He's been only 2.5 years, and he's not operating any wreckers. He's also helped us with the spills. In other words, when we have spills, hydraulic oil to clean up, and diesel fuel on the interstate, he's been a big part of helping me take care of the cleanups. And then done an extremely good job. Chad's an unusual young man. His past is very rocky, but he's given me absolutely no trouble at all. He is the icing on the cake for all the people that I have brought in and tried to get to do right. And he's absolutely caused no issues, no problem, and has done every single job I've asked him to do without any negative comment whatsoever. He did turn a page in his life for sure, and he's proved that to me.
Thank you, Mr. Mitchell. I know you've taken a number of people in and given them second, third, and fourth chances.
Yes, sir. And many of them unfortunately fail, but Chad is not one of them.
Yeah, and it seems like this time we're not being asked to take a chance on somebody. We're actually reviewing someone who has proven their worth to you already.
That's correct. Yes, sir.
Do any of the commissioners have questions of Mr. Mitchell or Mr. Owens?
I don't.
Mr. Fields, did you say your comment was that you would have approved him, but you were concerned about the forgery over $500?
Yeah, there were a couple of things that just I had some concerns with that, and all of them were old. None of them would preclude him being a driver, but it was the sort of thing, there was a theft it and there was a couple of things that were back actually in the 2000s. But when you look at his record, as he moved forward, he got to the point where they just went away. The last serious charge that he had would have been in
2015. Yeah.
Right, and it was dismissed. They did not. They chose not to prosecute, and the charge was dismissed. So I almost approved it, but then I remembered the commission, and I said I better bring him on to you.
Mr. Owens, Mr. Mitchell, I appreciate you guys being here today. Is there a motion regarding the application for record driver for Jason Chad Owens?
I make a motion to approve.
Is there a second?
I'll second the motion.
Thank you. All right, Mr. Rogers, how do you vote?
He gave a thumbs up.
All right.
Can you hear me?
Whoever's taking I do hear you now, Kerry, or
Okay.
Commissioner Rogers.
Aye.
Aye, okay. Ms. Westlake, Commissioner Westlake, how do you vote?
Aye.
Ms. Warren?
Aye.
Ms. Powell?
Aye.
And Mr. Carr, it's your motion. How do you vote?
Aye.
All right. Mr. Owens, congratulations. Your application's been approved.
Thank you.
And Mr. Mitchell, I again want to applaud your willingness to take people on to give them a chance. It's so hard for a person convicted of a felony to get a job.
I realize it is. You know, we've tried to actually get involved in changing some of those laws to actually help and be just a little more lenient if they've been out of it 10 years and haven't got any serious problems. I think they deserve a chance, and we're going to continue to battle that battle. But I want to thank the members for listening to all of our concerns and always having us make the right decision.
We try. Thank you, sir. In case the commissioners haven't noticed, I'm not asking you to raise your hands to make motions or to second motions. Please just speak up. I can't keep track of those hand signals down there on this thing anyway. Mr. Fields, our next item on the agenda is low-speed vehicles.
Yes, sir. The next was a application for a driver named Gary Hill. And I was unable to be in contact with him. We've left messages. He's not responded. We sent an email and it came back to me. So I have not, I've not heard from him further. I'm assuming he's changed his mind. I'd recommend we just withdraw his application, put it in a pending file. If he comes back, then we could bring him back if that's okay with the commission.
All right. Any of the commissioners have any questions or concerns? And if not, is there a motion?
I have a question.
Commissioner Carr.
How many times has this application been applied for?
This was his first application.
Okay.
Again, I think we could put it in a hold file without really any action from the commission, unless the commission obviously is not here, so you could take action on it regardless, because it was properly noticed, and he was properly noticed.
So we can either deny it, hold it in abeyance in a hold file, or grant it, but we're not going to grant it without him here. So Does anybody have a problem with just having Mr. Fields put it in a file to see if Mr. Hill ever surfaces again, and then after maybe 30 days or so, have it formally dismissed or denied?
I think that's the best idea.
Mr. Fields, can you put it in that hold file you're talking about, just hold it in abeyance, and at the next commission meeting, put it back on there so that we can take some action at that time if you do not hear from Mr. Hill again?
Yes, sir, or I can just simply deny it myself, and then he has a time period to ask for a hearing in front of the commission. So
I like that. Okay.
and he wouldn't have to come back unless he asks to come back, and so I can do that.
All right. Wonderful. And we do not have to have a motion or take any action today.
No, sir.
All right. Moving on to horse-drawn carriages. There's a review of a driver application for Dallas Corey Crawford. What's the status of that, Mr. Fields?
The company actually contacted me and said that they had planned not to hire him after all. I'd sent him an email, and he had responded that he would be coming to the hearing, but then after that, we heard from the company they had planned not to hear him or hire him. So he has not called into the meeting, even though he does have that information. He's very much like Mr. Hill, I think.
Would you recommend doing the same thing for Mr. Crawford? Put it in that hold file and then administratively dismiss it if we don't hear anything from him?
Yes, sir, we can certainly do that.
Because we're not going to grant it if he doesn't have a job. I mean, if he doesn't have a company that's going to employ him. So, okay. Mr. Fields, we're on to other passenger vehicles for hire. Review of company application for, I hope I'm pronouncing this right, Ahuha Limo?
Yes, sir, you have that application. It's a company application. You also have 3 address changes for Apex Transportation Services, for a move to a new address, as well as Black Ice Livery and El Boutros Limousine Services. All of them are in order, and I think you could take them as a group if you like.
Can I make a suggestion that we first vote on the application for Ahuha Limo, and then we'll take the review of the change of address in a separate motion, just so we can keep the minutes clear, okay?
That you are the chair. Yes, sir.
Only for the day. Is there a motion for pertaining to the application for Ahuha Limo?
I make a motion to approve the application for Ahuha Limo.
Thank you, Commissioner Carr. Is there a second?
I'll second the motion for approval.
And that was Commissioner Warren, right?
Correct.
Okay. Going down the line. Mr. Rogers, how do you vote?
Aye.
All right. Commissioner Westlake?
Aye.
Commissioner Powell?
Aye.
Commissioner Warren?
Aye.
And Commissioner Carr?
Aye.
The motion passes. Now we have Mr. Fields has informed us that everything's in order for the change of address of the 3 limo companies, Apex, Black Ice, and El Boutros. Is there a motion?
Nothing that would keep them from being approved.
No, sir.
I make a motion to approve.
And would that be for all 3?
That would be for all 3.
Thank you, Mr. Commissioner Carr. And the second coming from whom?
I'll second it. This is Carol Westlake.
Okay. All right, going. Mr. Rogers, how do you vote?
Aye.
Mr. Carr?
Aye.
Ms. Powell?
Aye.
And Ms. Warren?
Aye.
And Ms. Westlake?
Aye.
Motion passes. Now we have Metro Legal. Ms. Costones, Ms. Ladd, you want to take this away or take us down this trip?
Yeah, Billy, can I get permission to share my screen? I think Terry's gonna start, Terry's gonna do the presentation until she has to leave, but I'm gonna share my screen in case she has to leave.
I apologize for having to take off a little early. We're hoping we can get this done in time before I have to leave at 2:20. But, you know, if y'all have some questions, certainly we don't want to cut you off. And so we're going to tag team it a little bit in order to make sure that you get a chance to have as full a discussion as you want while keeping Mr. Fields' requested time constraints and the weather in mind.
You guys see okay?
Yes, ma'am.
Yeah, and I don't want to put any pressure on anybody, but I have. Thank you.
Mr. Chair, you are cutting out on me a little bit.
I was just saying I have to leave by 2:15 as well. So thank you.
Okay, we should be close to the end by then. Okay, Tara, can you go ahead and take us to the first slide, please? Okay, so we're going to have 6 goals to this training. The first one is to understand that you cannot accept benefits relating to your role on the board. The second one is to understand that you may be, that when you may be biased or have a conflict of interest, you should recuse yourself from a vote on that matter. The third is to remember to disclose knowledge that you have received about an agenda item from outside the meeting. The fourth is to remember to articulate the specific reasons and basis for your decision. And the fifth is to understand that the Open Meetings Act prohibits deliberation outside of public board meetings, and that the Public Records Act makes almost all your emails open to the public. And of course, that would be almost all your emails that are related to Metro business. Certainly your personal or private business emails would not be. And 6, finally, understanding the best practices for making informed decisions. So we'll start first with the first goal about what benefits you can accept related to your role on the board. And there is a chapter of the Metropolitan Code. It's Title II, Chapter 222, and that contains the General Ethics Ordinance. And it refers to Metro employees, but the term employee is a defined term that is defined to include any member of a board, agency, commission, or authority. So that includes all of y'all. And it has a number of different prohibitions on conduct for such persons, but those include a prohibition on accepting or soliciting any benefits that might reasonably tend to influence you to act improperly in the discharge of your official duties, a prohibition on using Metro property services or funds for personal purposes. I don't think that one should be too much of a problem for y'all, as I don't think we really give y'all too many property services or funds belonging to Metro. And the third one is to be careful not to use non-public Metro information for personal gain or for the gain of a family member or employer. And again, that's probably not going to come up too often because most of the information we discuss is in the open meetings context anyway, and maybe that would come up in the context of an executive session or something like that. Some additional prohibitions include a prohibition on using a Metro position improperly to secure unwarranted privileges or exemptions for yourselves, your relatives, or others. Another one is prohibition on accepting other employment which might impair your independent judgment in the performance of your Metro duty. And the last one is prohibition on accepting any benefit which the employee, you, in other words, as the commissioner, should reasonably believe was intended to influence any action taken in your official capacity as a commissioner. Go on to the next screen. So while those prohibitions are pretty general, there are some exceptions to that that I think are pretty common sense. The first one, it's fine to accept awards of trifling value publicly presented in recognition of public service. So if Billy gives you a plaque or something like that, it's fine to accept that. I suppose Billy wouldn't be trying to influence you to do anything improper anyway, but gifts unrelated to a person's position as a Metro employee are perfectly fine, of course. You can accept birthday gifts or whatever from friends and relatives that have nothing to do with you being a TLC commissioner. Meals, beverages, food promotional items, or hand-produced items of a value of up to $25 from a single source in any calendar year. I have kind of a funny story about that one. I was sitting in the back of a council meeting during kind of the announcements at the beginning of a council meeting, and was sitting next to another Metro legal lawyer. And it used to be that you could only accept food up to $25 and you couldn't accept other items. But then they changed that to say you could accept other items as long as they were $25 or less in value. But before they changed that, we were watching the announcements, and one of the council members accepted a gift of a baseball cap from a constituent. And, a couple of the lawyers in the back of the room were kind of shaking their heads. And so my colleague quipped, "It's fine as long as he eats the hat." But now you can accept the hat even if it is not edible. Free or discounted admissions tickets, access to events, or travel expenses from any single source of any aggregate value in any calendar year of up to $100. This is the one that I probably get questions about the most. A lot of times, and a lot of times it's more employees than commissioner board members, but if somebody offers to fly you somewhere, almost any airline travel cost is going to be over $100, or a symposium or event or something like that is often over that amount as well. And that's for an entire year. So, and as long as it's from the same person. Same thing with the $25, that's for an entire year, as long as it's from the same source. So, in general, really modest trifling values is what is okay. Anything above that is problematic. And you can always call me, and Tara will always be glad to talk you through anything like that you get offered that you have questions about. Go on to the next slide, please. Okay, so there is actually a body, another board, a different one from y'all, that actually has this area as its area of specialty, and that is the Board of Ethical Conduct, which is created in the Metro Code in Chapter 222, Section 040. And they do two things. They hear complaints. So if somebody makes a complaint about your ethical conduct as a commissioner, they will make it to this other board. And they also can render advisory opinions. So certainly, like I just said, you can start with me and Tara if you are looking for an advisory opinion about your own conduct. But if you want something really official and really formal and have a little time to wait for it, an opinion from the Board of Conduct is something you could seek. In theory, that's not done all that often, and in practice, I think it would be written by one of our colleagues in Metro Legal and approved by the board, but that is an option. Like it says, any elected official or member of a board or commission can request such advisory opinions. Now, if you were to get an ethics complaint filed against you, here's the procedure that would follow. And hopefully none of y'all will have to be in this position, but at least this way, if you are, and I'm sure it would be a non-meritorious complaint, but we would follow this procedure. So they are made to the Board of Ethical Conduct, as I just discussed. Then my department would investigate, evaluate, and make a report to the board regarding whether the facts, if proven true, would amount to an ethics violation. Obviously, if they would not amount to an ethics violation, then there's no reason for the board to hear it. However, if there are enough facts out there that it's arguable that they could amount to a violation, then the board would hold a hearing, and the parties would be given an opportunity to present their case, both sides of the case, the complainant and the person complained about. You can go on to the next screen. Thanks. Okay, so penalties for violations. The board can recommend to council that the person complained about be censured. They can recommend that the person resign his or her position on the commission. In extreme cases, they can refer the matter to the District Attorney General for prosecution. And I'm not sure I'm aware of a single instance where this has ever been done, but theoretically, they could refer the matter to the Director of Law requesting that civil action be initiated for restitution or other relief. I think that would be much more likely in the case of an employee who's actually employed by the government as opposed to a commissioner, like someone who embezzles or something like that. The second goal of the main 6 goals that we started out with was to help you understand when you may be biased or have a conflict of interest that would require you to recuse yourself from a vote on a matter. So that has to do with your duty of independence. You are obligated to act as a commissioner in an impartial way, which means that you cannot act based on your own self-interest or based on a bias against or in favor of people that you know personally, or based on the interests of the director or contractors with whom your board interacts. So you are even required to be, not to be partial in favor of Mr. Fields or anyone else that you work with regularly in your role as a commissioner. And you must be impartial and act based on the law and the evidence presented to you. All right, we can go on to the next one. So if you think you might have a potential conflict, here's the analysis that you would use to determine if you have to recuse yourself from a vote on that matter. Now, once again, I will emphasize you can call me and Tara. We will be glad to walk you through it at any point in time. But one of those instances would be if you have some kind of personal interest where you will lose or gain money, it would pretty directly flow from the decision that you would be making in your role as a commissioner. You'd also be biased or prejudiced if you have a prejudice for or against a party, either as an individual or a member of a group. If you're close friends or business partners with someone who's coming before the commission, for example, or if for some other reason you feel you cannot be objective, we would usually advise you to err on the side of caution and go ahead and recuse yourself. You cannot, and if you cannot fairly or impartially weigh the evidence because you have prejudged factual issues. And you can see that there actually is a case cited at the bottom of that slide. These are not just abstract ideas. Every now and then they come up and actually are dealt with in the context of litigation. It is important to take these seriously. And you do not have to recuse yourself if you will not gain or lose any money fairly directly from the decision. And if you can be objective and do not believe your participation will create an appearance of impropriety. In that case, disclose your potential conflict, but state that you believe that you can be unbiased and will participate. So even if you are convinced that you can be completely objective and that the kind of connection that you have to a matter is so tenuous that it will not affect your ability to be impartial or even give you an appearance of impropriety, you should nonetheless disclose it to the public and to the other commissioners in order to kind of be as transparent as possible. And again, if you're uncertain about any of this, please talk to Billy, please talk to me and Tara, we will help. All right, the third goal that we were addressing with this presentation was to disclose knowledge that you have received about an agenda item from outside of the meeting. So that's kind of similar to what we were just saying at the end of the last goal. Are there more bullet points to come down on that one, Tara? Thank you. The first one would be, like we just said, you're usually going to either choose to disclose or recuse. Disclose in the kind of more mild type issue and recuse in the more serious type situation. So knowledge that comes from outside the meeting can include attempts to lobby you. So we had talked about this before, maybe Ms. Westlake hasn't heard it since she's relatively new, about the need to avoid ex parte communications when a board or commissioner member is acting in an administrative or judicial capacity. So basically, if you are acting in kind of a quasi-judicial role, if you're kind of making a decision based on two sides being presented to you, then in general, you should not be having ex parte communication with either side before the meeting. And it can also be that you happen to know something from your own personal experience or professional expertise about an issue or an area of town when making such a decision. You should disclose that also. You know, that maybe in boards and commissions that deal with locations or buildings or things like that more than you all do. You will often hear board or commission members say, well, I drive by that every morning on my way to work, and you know, that kind of thing. And again, you'll see there is a citation to a legal matter that came up at the bottom of the page. So these can actually be litigated, and so we should really be careful to avoid that liability. The fourth goal is to remember to articulate the specific reasons and basis for your decision. I think you all are generally pretty good about this. That is important in light of the possibility that your decision could be appealed. And it shows that you are following what you should and analyzing what you should in the process of making your decision. What we want to avoid is any decision that is arbitrary and capricious. So you would be, acceptable reasons that you could give for a decision would be that you are considering the criteria of the relevant guidelines or laws. You're considering the facts presented to you at the meeting. Often, like, parties may present evidence, like complainants. You can take into account past experience with similar issues. So we'll often do that in terms of the disciplinary matters that you all hear. Like if you think, well, you know, so-and-so did that previously and we gave them a 30-day suspension, so maybe we should consider a 30-day suspension here too. And studies by experts or specific observations made by the public that are presented to you all may also be taken into consideration. All right. And some unacceptable reasons would be an expression of sympathy for the applicant or for people who are opposed to the approval. So that would kind of negatively impact your appearance of impartiality if you were to engage in that. And opposition that's not based on the relevant guidelines or law. So like if you go outside what the Transportation Licensing Commission is kind of charged with, if you are basing your decision on something that is kind of outside of that jurisdiction, if you will, and the example that's given is that the project may be noisy and we already have too much traffic. That's maybe not the best example for the TLC because the too much traffic might be something that you actually could take into consideration. But noisiness probably isn't really that much your area of expertise. And so that might be more like codes or police. And so as you can see, once again, there was a case at the bottom of that last slide. So these matters do get tried. We do get sued over them. And a fifth goal is to understand the Open Meetings Act and the Public Records Act. Again, generally that comes up in the context of emails, but it can apply to other documents and other situations as well. So we actually had an interesting discussion about this at a board meeting yesterday, where one of the board members asked if they could use the chat feature to talk to the other board members on one of these WebEx presentations. And we had kind of had to scratch our heads and think about that, because there is a specific prohibition in the Open Meetings Act that says that board and commission members cannot engage in electronic deliberations with each other. In general, that has been in the past, though, interpreted to mean email exchanges. And of course, if you're talking to someone about like the new restaurant that just opened up, or your favorite sports team, or something like that, or your grandchildren, that's all fine. But if you're talking to someone about a matter, if you're talking to one of the other members of this commission about a matter that may come before this commission by email or on the telephone, you should not be doing that. You should be holding that discussion to have it in the public eye at a properly noticed open meeting like this is. Email can be a public record even if it is not on an official Metro email account. So if you use your personal email address, but the email that you send is about Metro business, it may be deemed to be a public record. So you should be conscious of that in sending email as well. I would also say, in terms of the prohibition on electronic deliberation, even if you can't talk to each other, it's always fine for you to reach out to Billy or to Lisa or to me and Tara. Conversations with staff are not prohibited. It's just kind of the collective conversations among commission members. And then finally, violations of the Open Meetings Act also make decisions based upon those deliberations void. And it says a judge may also order court supervision of a board. And that has happened. You see the case citation at the bottom of the screen again. We've had board and commission members deposed in cases about this electronic communication issue. And so that is really something to avoid. You definitely don't want to be put in that position. So better to err on the side of caution. Another question that comes up in the context of the Open Meetings Act is the definition of the word meeting. Because what if two of you just run into each other around town somewhere? Because Nashville can be kind of a small town. And that is fine. Although, once again, in having that accidental run-in, you should still avoid conversation about a substantive matter that may come before the commission. But a meeting is officially defined as when two or more members of a governing body with the authority to make decisions for or recommendations to a public body meet and make a decision or deliberate toward a decision. So it's those two things, making the decision, i.e. voting, or deliberation, that are the things that are really problematic outside of the open meeting context. The Open Meetings Act also requires that adequate public notice must be given for all meetings, and Billy is very good about making sure that that is done. The notice must inform affected parties of their opportunity to be heard and give them time to prepare for and anticipate the meeting. And there's not a particular number of dates that any law or decision specifies is the magic number for that amount of notice. But instead, it's more flexible. It's adequate public notice, sufficient notice under the circumstances. So that's been kind of something, a rule that's been developed in case law, addressing conflicts over this issue. All right, and what is not a meeting, there's a list of exceptions of things that you can do even outside of the context of a public meeting. On-site inspections, chance meetings, or informal assemblages. I love that word. I always want to pronounce it very French. And attorney-client meetings. And this has happened with the commission a couple of times. Some of you who have been on the commission for a little bit longer may recall having executive sessions with myself or with litigators in my office who were working on a case involving the Transportation Licensing Commission. You don't get sued too much, but it does occasionally happen. And basically, the concept of an executive session is going to be that you will need to have a private meeting with the lawyers in which the lawyers will be making an informational presentation to you. You cannot actually vote in the context or deliberate in the context of an executive session. So we would probably hold the executive session. You could ask questions of the lawyers could answer those questions, but you can't talk to each other. And then after that executive session is over, we would go into public meeting session where the vote would actually be taken on whatever matter if the vote is needed. And I think I'm going to go ahead and break off at this point and let Tara take over. I don't think there is too much left on the presentation. But I apologize for slipping out on you, but I know Tara knows this stuff as well as I do. So enjoy the rest of your afternoon, and I will see you all next time.
Hi, guys. Just another couple of slides. We're almost there. So we've talked about it at the beginning of every meeting so far, the electronic meetings under the governor's executive order because of the pandemic. This is only temporary. These have to be issued by the governor, and they have separate requirements, which is one of those requirements is that motion that you have to make at the beginning, that the agenda constitutes essential business of the body. You have to conduct votes by roll call to make sure that everyone's voices are heard, so there's no confusion. And meetings have to remain open to the public and accessible by providing call-in or video access to members of the public, which is all stuff that we do. All right, more continued. A recording has to be made public after the meeting. Of course, all these things we already do. The public notice must inform the public that the meeting is electronic and how to watch in real time and participate. And the boards are strongly encouraged to include the agenda in the notice. Meeting participants should identify themselves in a manner reasonably calculated to permit the public to ascertain the identity of the person speaking. And public comment should be substantially similar to pre-COVID conditions, but accomplished by reading submitted comments into the record during the meeting. And all these things are things that we've had to adapt to this past year. Goal 6, understanding the best practices for making informed decisions. Best practices for staff, which is not you guys, is what this is Billy's domain, is to provide a detailed agenda for each meeting, ideally at least a week ahead of the meeting so that the public can be informed of the issues that are going to be deliberated on and decided on. And the board may review relevant documents or contracts in preparation for the meeting, which you guys get those documents to look at so you're not surprised by what you see. Provide staff a report or recommendation for each agenda item in written or oral form with the reasoning behind this recommendation. And starting each meeting with the declaration by any board members of conflicts and or recusals on agenda items, which, as Terry stated, if you have any of those, give us a call and that's the procedure that we would follow. All right, best practices for board members. This is for you guys. Make sure you understand the work of the department staff that your board is responsible for. For example, have you met the leadership? Have you asked to review key organizational documents and contracts to understand your legal role and some history of past decisions that your board has made? Before each meeting, make sure you review the agenda and copies of relevant documents or contracts that you'll need to make an informed decision on. Ask questions about anything you don't understand, and please note any conflicts that should be disclosed or warrant recusal. And consider adopting metrics for your board to measure whether you're acting timely or in accordance with your board's duties. And we don't have that, but you guys, as far as I know, but you guys are always on top of things. All right, my job was pretty easy. I only had 3 slides. If you have any questions, these are the 2 attorneys in our office that prepared the PowerPoint, but as always, you can contact Terry or I to discuss any of these things that were talked about in this presentation.
Thank you, Tara.
Yep.
Any of the commissioners have any questions? All right, well, it's always good to review these bullet points and the possible issues that could arise. I know for myself, I'm going to be more careful looking at the agenda and spotting any potential conflicts so that I can bring them up before we start the meetings. All right, is there any new business tonight or today?
I have no new business other than to tell you there will, I'm very hopeful we're going to have SUMD business for you in April. Depending on the nature of the business, I may have to ask you for a special meeting. We can, for at least one more month, we will be able to have WebEx meetings. The governor's executive order expires at the end of April. So April also may be the last month of WebEx. We may be coming back live in May. We'll have to wait till the governor, but I will keep you informed as I'm informed on SUMD issues. Other than advising you of that, I have no new business, Mr. Chairman.
All right. Do I have a motion to adjourn the meeting?
I'll make a motion to adjourn the meeting.
Thank you, Commissioner.
I
Second.
second that motion.
All right, that was Commissioner Carr. So let's just have a voice vote on that. Everyone in favor, say aye.
Aye.
All right, sounds unanimous to me. So motion carries. Everybody have a good evening. Be careful.
Thank you.
Bye. Thank you.
Bye.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.